United States Supreme Court Justice Samuel Alito gave an important speech about the importance of the First Amendment and how it is at risk. I'm going to explain to you why this speech is so important to your Second Amendment rights and why this is another indictment of the so-called tiers of scrutiny methodology that the anti-gunners so desperately want the court to embrace to balance away our rights, our Second Amendment rights, and our free speech rights. Let me connect the dots for you and make you the smartest person in the room when we're done in one moment. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of many Second Amendment related books, including Disarm What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, so we have a lot of important news we're going to break down for you right here, right now about the Second Amendment and the First Amendment. Last week, Supreme Court Justice Samuel Alito gave a speech as part of a commencement address at the Franciscan University in Steubenville, Ohio. And in it, among other things, he talked about how free speech, which is protected by the First Amendment of the Bill of Rights, is under assault. Specifically, some of the comments he made is, quote, support for freedom of speech is declining dangerously, especially where it should find deepest acceptance, specifically referencing universities and the history of debate at these public universities. Now, the reason why this is so important to our Second Amendment right to keep and bear arms is as follows. As you may recall, prior to Nysurpa versus Bruin, the lower inferior courts in the judicial system tried to balance away and did in fact balance away our Second Amendment right to keep and bear arms. And they did that by trying to apply, and we're going to break it all down for you in just 1 second, they would apply things like intermediate scrutiny or tiers of scrutiny, which, as I've taught you on this channel repeatedly, those words are euphemisms. They're euphemisms for something extremely bad. Whenever you see the words tiers of scrutiny or intermediate scrutiny or strict scrutiny, those are euphemisms for giving judges the power and authority to balance away your rights in the name of government power and government interest. It's extremely bad. Now, the reason why this is important to understand and why it ties into Justice Alito's discussion last week with those college kids about the First Amendment is because the jurisprudence of the First Amendment right to free speech is tiers of scrutiny. So what I want to do now is explain to you how this is very dangerous in the context of the First Amendment, and then explain to you why the anti-gun movement wants to take that First Amendment-related jurisprudence of tiers of scrutiny, cut and paste it, and apply it to our Second Amendment rights to give the government more and more and more opportunities to steal our rights and balance it away with friendly anti-gun judges. But to begin, let's just talk briefly about how the First Amendment right to free speech rules work, or the way you interpret the First Amendment and apply it in First Amendment fights when there's an allegation that the government has violated someone's right to free speech and thus has violated the First Amendment. Remember, the First Amendment is part of the Bill of Rights, like the Second Amendment. They were all adopted and ratified and went into effect in the year of our Lord, 1791. So you would think that the First Amendment methodology for interpreting what it means should be consistent with the Second Amendment, and that is absolutely correct. But over the last many decades, there's been these barnacles that have been attached to the First Amendment by liberal justices to make it easier for the government to win. Those barnacles never attached to the Second Amendment because, ironically and luckily, the liberals never bothered to handle any Second Amendment cases, so they never screwed up the jurisprudence of the Second Amendment because they simply ignored it and pretended it didn't exist. That they pretended the right to keep and bear arms was not part of the Bill of Rights, which in the long run actually may have helped us out because they didn't screw up the jurisprudence, which allows us in the Second Amendment community and justices that respect the Bill of Rights and respect the text of the Constitution to get it right without having to undo a bunch of barnacles on the law created by liberal judicial activists, which is what they probably need to start doing in the First Amendment. Now, the way it works in the First Amendment, and you will see exactly how this game gets played to take away constitutional rights. The first is, at the first level, the Supreme Court has taught that you read the text of the First Amendment, and that is, of course, you cannot infringe or abridge, right? You cannot abridge or infringe the right of individual free speech, okay? Now, at one level, it's very straightforward. Speech can be what I say, what I write, Even how I dance, for example, if I give you the finger or I thumb my nose, those are actions, right? Nevertheless, those are all considered forms of speech. So once something is a speech action or a speech word or whatnot, it's conveying a message, or wearing, for example, a black armband to protest the Vietnam War is another example the Supreme Court says is a form of speech. Keep in mind that under the First Amendment, the first part of the First Amendment analysis is very similar to the Second Amendment. What I mean by that is you look at the plain text of the First Amendment, free speech can encompass statements as well as actions. We've talked about this, including like art. Beyond that, the question is, historically, is there a historical exception to the First Amendment? And there are a series of historical exceptions. For example, the First Amendment just doesn't protect as speech obscenity, fighting words, libel, slander, fraud, things like this. It's just not historically protected. The founders would not understand that to be protected by the First Amendment. Sounds a lot like the Second Amendment. But here's the key. When something is deemed speech and does not fall within one of those exceptions, again, obscenity or libel, slander, fighting words, etc., guess what happens? Well, in the First Amendment context, because of liberal judicial activism, the government can still win the case by showing that the interest in the government or the governmental interest is so important that it overrides the protected or the otherwise protected right to free speech. That's the key. You see, it gives the government two chances to win. They can win at the textual level and the historical level, and if the government loses at those levels in the First Amendment context at least, they get another bite at the apple by arguing that the interest of the government in censoring speech is so important that guess what? They get to do it, notwithstanding the fact that that speech would otherwise be protected by the Constitution. Here is, for example, a statement made by Justice Brown Jackson in a recent Supreme Court case where she's concerned about hamstringing government.
Justice Jackson?
So my biggest concern is that your view has the First Amendment hamstringing the government in significant ways in the most important time periods. What would you have the government do? I've heard you say a couple times that the government can post its own speech, but in my hypothetical, kids, this is not safe, don't do it, is not going to get it done. And so I guess some might say that the government actually has a duty to take steps to protect the citizens of this country, and you seem to be suggesting that that duty cannot manifest itself in the government encouraging or even pressuring platforms to take down harmful information. So can you help me? Because I'm really worried about that because you've got the First Amendment operating in an environment of threatening circumstances from the government's perspective, and you're saying that the government can't interact with the source of those problems.
Now, you just heard Justice Brown Jackson worried about government being hamstrung from doing its job in protecting us. Basically, she's indicating that she supports government restricting speech if the speech potentially is problematic and the government has an interest in thwarting it. Now, this is where Justice Alito's comments are so important, because today, if you look on college campuses, especially at the law schools, and people recently that have graduated from law school, what do you see? Well, you see a group of people that are quote-unquote progressives or liberal that don't seem to have the same level of respect for free speech rights and debate that, for example, older liberals might have. If you see, for example, Alan Dershowitz on the Fox News channel, which, you probably see us, me on there and Alan Dershowitz on there and so on. Even though Alan Dershowitz is a longstanding liberal that never votes, I think, for Republicans, basically, I think he's admitted he's never voted for Trump, for example, he still supports the right to free speech. And what's happened is, and this is where there's a false sense of security about why the perception is that tiers of scrutiny is good for rights, is the idea is that over the last many decades, and here's the key, over the last several decades, the courts have protected free speech rights using the tiers of scrutiny. So people say, aha, tiers of scrutiny must be good for the Bill of Rights because look over the last several decades how even liberals have protected fundamental rights in the First Amendment context, and therefore that's a good thing. But here's the thing to understand. That is assuming that the current and future justices and judges on the federal bench are like the prior ones, and that's not the case. And this is where Sam Alito's comments come into play, because in the older generations, where you had liberals like Professor Larry Tribe of Harvard, Alan Dershowitz of Harvard, you had people like that. They believed in free speech. They believed in debate. The ACLU was all in on free speech and free debate and having arguments and all this stuff, because I think part of it was that the one thing that judges understand is they may not own guns or understand guns, but the one thing that judges over the years do understand is words, lectures, books, because think about it. You have to be pretty academic and intellectual to be a judge and to be a lawyer and to go to these elite law schools. So you better enjoy reading books, because that's what you're going to do a lot. You better enjoy going to lectures, because that's what you do. You better enjoy giving speeches. You better enjoy doing debate, because that's what you do. So there's a long-standing history of judges and law professors and law students enjoying words, speaking, arguing, reading. You see what I'm saying? So there's this respect for free speech that has existed, which as a result has caused judges on the bench today to, when they apply the tiers of scrutiny, to overwhelmingly support the right to free speech. But, and here's what you want to understand looking down the chessboard, but, if today's law students, and right, if today's law students that we see protesting on these campuses and doing crazy stuff, these are the people that do not seem to respect the right to free speech like their forefathers did. Right? So what's going to happen is, I predict, is this is what Sam Alito is referencing, is going forward, these law students that have been taught that free speech is bad, it's a white privilege, it's, toxic chauvinism, whatever. I've lost track of what they call this stuff, but basically it's, Western civilization, chauvinism, whatever. The reality is that when they sit on the bench as judges, when they look at a case and decide whether or not to balance the governmental interest in suppressing or oppressing free speech on the one hand, and they balance it against my right to free speech on the other hand, they're going to be much more inclined to say that the value of suppressing free speech is justified and it's more important and more valuable than my right to speak out. So the problem is that the judges, if they change over time, will be able to manipulate this very malleable tiers of scrutiny, strict scrutiny, intermediate scrutiny rules, and that's extremely bad. Now, the reason why I want you to understand this in the First Amendment context is because the anti-gunners are desperate, absolutely desperate to bring this back to the Second Amendment context, because between 2008 Heller and 2022 NYSERDA versus Bruin, the lower courts all did exactly this. They embraced this notion of these First Amendment approaches, where the first question is, does the right to keep and bear arms get infringed by government regulation? If no, then the government wins. If yes, then the government gets another chance to win, because then what happens up until NYSERDA versus Bruin, they would then say, okay, but is the government interest in restricting your right to keep and bear arms justified? In other words, is the government interest in preventing mass shootings and preventing criminals from doing bad things overwhelm your right to keep and bear arms? And during that time period of 2008 through 2022, all these judges embracing this First Amendment tiers of scrutiny methodology over and over and over again said that the government interest in stopping criminals from doing bad things with guns overwhelmed and outweighed your right to keep and bear arms. This is why it's absolutely terrible. So again, we never want this in the Second Amendment context, and we don't even want it in the First Amendment context. And to the extent anyone says to you, look, hey, Mark, look at the last 30, 40 years, the First Amendment has been robustly protected by the federal courts using tiers of scrutiny. And therefore, the tiers of scrutiny is a great way to protect the Bill of Rights. That is utter BS. And they're misdiagnosing the reality of the malleable standards of tiers of scrutiny. And they're doing it because for the last 40 years, even, the conservatives always believed in debate and fights and arguments, right? Okay. But then the liberals do the same up until now. But now going forward, you're going to see more and more judges and justices like Justice Brown Jackson and these other progressives that simply do not value debate and open discourse and open discussion the way prior generations of progressives and liberals did. So going forward, the people that you see shutting down speeches on Ivy Ivy League campuses, they're going to graduate into becoming lawyers and judges. And when they balance your right to free speech against the government's interest in stopping free speech or censoring, they're going to be much more inclined to support the government. So any notion that tiers of scrutiny is good at protecting our fundamental rights, whether it be in the First Amendment or the Second Amendment context, that is simply a false sense of security. Don't make this mistake. Don't believe this. So again, I wanted you to understand exactly how this game is getting played so you get ahead of it. The good news is the U.S. Supreme Court right now understands everything I just said, and that's why they're so firm in making sure that the notion of tiers of scrutiny, which is again is a euphemism for balance away your individual rights in the name of government power, that is why this Supreme Court is not going to expand the tiers of scrutiny. And in a perfect world, they would go back and get rid of the tiers of scrutiny in, for example, the First Amendment context too, but they haven't got there yet because again, like I said, in the Second Amendment context, you don't have the barnacles because there was no terrible Second Amendment precedents on the books. In contrast, you have years and years and years of terrible anti-First Amendment precedents on the books involving tiers of scrutiny. That will take time for them to clean that up. They may never get to it, but we will see. All right, folks, hope you learned a little bit something here today. Hope this was helpful to understand why you don't want tiers of scrutiny under any sort of circumstances. You want text and then history like we've talked about. And Justice Alito alluded to this essentially with his speech out there in Steubenville, Ohio. And again, we look forward to seeing you. Don't forget to follow me on X at 4Box Diner. And don't forget to subscribe and resubscribe here. A lot of people keep getting knocked off. I know my friends have told me that they don't get fed my videos, even though they literally have watched every single video I've ever done. So if they're getting knocked off and not getting these videos fed, then, we got to be aware of that. And maybe you guys can help spread the word. And we will see you again soon here at the 4Box Diner.
Orders up. Table 2A.